All right, welcome everyone. It's about one after, and we have half of everyone that registered. Um, I'm going to pass it over to, we have Sherelle Towns from the Coordinating Center today, and Kelly with us from KMC Law Partners in Planning. And I'm going to pass it right over to Kelly.
Hi, everyone. Thank you for signing up today and for joining us. And thank you to the Coordinating Center for having me back. Today, we're going to talk about supportive decision-making as an alternative to guardianship. So Heidi, if we can go to the next slide. This PowerPoint will be shared with everyone after the presentation. And if you have questions, you can put those into the chat and we will answer them at the end. And then you can certainly reach out to me if you have questions after the presentation. So our first slide is talking about our alternatives to guardianship, going from least restrictive to most restrictive. And supportive decision-making is about in the center because it works with the agents for the power of attorney, a trustee, or a guardian. So if we want to go to the next slide. This is just a little reminder about capacity. It's that all adults are presumed to be competent to make their own decisions about their personal well-being and their money unless a court determines they are not. So when we talk about lack of capacity, we can move to the next slide. There's different meanings for different legal documents. But for guardianship, it is when two physicians, psychologists, or a certified clinical worker determine that an adult is unable to make responsible decisions regarding their care. And is the key part, is there are no other alternatives available to guardianship. And with guardianship, as most of you might know, the person's not able to make their own choices about where they live, they work, their medical treatment, and what care they receive. And that's where advocacy for supportive decision-making has come in. If you want to go to the next slide. So supportive decision-making is an alternative, but can also be used in conjunction with guardianship. To allow for a level of independence for the adult. So before a court will consider guardianship now, they must see if there is a least restrictive alternative, such as a supportive decision-making agreement in place. And adults that have a current guardianship can still put in a supportive decision-making agreement to regain some of their decision-making abilities. So we're going to go through a little bit more in detail about the Maryland statute. We have a sample of a supportive decision-making agreement for you. And then I'll have a few things on trustees, power of attorney, and advanced medical directives towards the end. We want to go to the next slide. This gives us a little bit of background on what supportive decision-making is. It's a process where adults receive support to make, communicate, or effectuate their own life decisions without transferring decision-making authority. You and I do this all the time. We reach out to family, friends, coworkers, maybe folks in our church as we're trying to process our decisions and asking for advice. So folks that have a diagnosed disability can also do the same thing, just to seek that kind of support for things they may not understand or to talk about the pros and cons before making a decision. And we all use this, to promote our own independence. And for individuals with a disability, it would be to encourage their self-reliance and confidence. And the nice thing about the supportive decision-making agreement is it's customizable and tailored to a person's specific needs. So it's just another tool to help folks communicate and make decisions for themselves. So we can go to the next slide. So some of the things to kind of consider when talking about what skills we need as we're advancing in life is, you know, how do we manage our money? How are we making our healthcare decisions? How do we decide where we're going to live or who we might live with? What information do we need to make an informed decision? And what help might we need to communicate that decision for ourselves? So if you are a parent of a child that's still school aged, I would encourage you to think about, you know, asking these questions and going through this with your child as you may make some important life decisions, to kind of talk through them, to say, you know, this is the information that I gathered. This is how I came to the decision that I did. And it's to give them practice with making decisions, because we want to make sure that folks are not deemed in to have an incapacity because they just haven't had an opportunity to practice making decisions. So it's just a few things to kind of think through. And go to the next slide. So in the state of Maryland, all adults are presumed capable of making a supportive decision-making agreement. And the manner in which they communicate with others is not grounds for determining that they are incapable of making, changing, or revoking a supportive decision-making agreement. And that's pretty important language, that everyone is presumed capable of doing this. We can go to the next slide. Not all states have supportive decision-making laws. This is the list of states that currently do have them. States that don't have an SDM law, they don't necessarily have to recognize an agreement that was created in one of these states, but they might. But it's just kind of knowing, if you are trying to decide if the SDMA is good for you or your child, and you start Googling them, you do need to make sure that the state that you're aligned with and living, it follows their statute, because some of them are going to be a little different. We're going to focus strictly on Maryland today. So we can move to the next slide. So Maryland's SDM law became effective in October of 2022. So in the grand scheme of things, this is still very new, probably for a lot of providers. You may run into some third-party users that just are not familiar with it and may ask you questions about it. But some really important things to think about at the beginning, and what a supportive decision-making agreement does not do. It does not supplant the authority of a guardian of an adult unless the court authorizes the limitation or removal of guardianship due to the existence of the SDMA. So while an individual who might be under court-appointed guardianship can have a supportive decision-making agreement, it does not supplant the authority of the guardian unless the court authorizes it. Another key piece is it does not supplant the authority of an agent under a power of attorney or an advanced medical directive, and it cannot give authority or agency powers contemplated by a power of authority or advanced medical directive. So an SDMA is used to support or works in conjunction with these, but it does not supplant or give authority for them. And that is some pretty important information. The next slide, please. So here's some areas of support for consideration. Excuse me. To gather information, to help understand and interpret information, weighing options or alternatives, understanding the consequences of making a decision or not making one, participating in conversations with third-party organizations with the adult's authorization, and to provide the adult with support and advocacy when implementing a decision. So again, this is, think about your own self. You know, how are you gathering information before you make a decision? Who do you turn to help understand and maybe interpret information, or to weigh your options when considering your alternatives. This is just a more formalized structure of what folks do on a daily basis. And we can go to the next slide. So the statute does lay out some supporters' duties. Most importantly, you're going to act in good faith. You're going to act within the authority of the agreement. Avoid a conflict of interest. One of the important things is supporters shouldn't judge the reasonableness of the adult's wishes, their preference, or their choice. Even though you might not agree with what the adult decides to do, you are there to help them provide information and make a decision, but it is not your decision to make for them. And so because you don't have an agency relationship with the individual, or on behalf of the individual, they make their own decision. And the supporter has no authority to act on behalf of the individual. That's where that agency piece comes in, that we said a SDMA does not give the supporter. Next slide, please. This goes into a little bit more detail that a supporter is not making a decision on behalf of the adult. You're not supposed to exert undue influence over the adult or coerce them into your thinking of what their decision should be. They can't obtain information without the adult's consent or enforce the decisions. So yeah, this really comes back to that judgment piece on the supporter is there to help guide, but not make a decision on behalf of. Next slide, please. We have some folks that cannot be a supporter under the statute. It can't be a minor, can't be someone that the adult has a peace order against or a protective order, somebody who's been convicted of financial exploitation, or someone who is subject to civil or criminal order that prohibits contact with the adult. We can go to the next slide. So how do you create an SDMA? And the statute was designed to be simple in concept, and it shouldn't be complicated beyond the simplicity, right? You identify the areas where support is needed. You choose a trusted supporter who's willing to assist. It could be a parent, it could be a family member, it could be a teacher, someone else in the community that the adult trusts. And it doesn't have to be for all decisions. You can have a different supporter for different areas of their life that they wish to seek support. And then you draft the agreement, sign and date. The Maryland Disability Rights Maryland has provided a sample template, which we're going to look at next, that gives you a really well laid out base for getting started on creating an agreement. So Heidi, if we can go to that. So it gives you the information about the statute. You must be an adult in order to create this agreement. And we can kind of scroll down. The first page is for the adult that is drafting the agreement. You can put in the details about how you communicate and the people, if there's anyone that they don't want to help them make decisions. When we get to part 2, that's about picking supporters. If the individual has multiple supporters, they will have to complete pages 2 to 8 and then 14 and 15 for each person. If we can slow down right here on page like 4 or 5, this is where each supporter could be identified on where the individual is looking for help. If they have maybe a family member or a friend that works in the healthcare industry, maybe they say, I want that person to help me with health, but I want maybe mom and dad or a teacher to help with education. So if they have two different supporters, then each supporter would have to fill out this section. And that's where you go into the detail about the topics or tasks and how the individual is asking for help from the supporter. This covers healthcare, education, housing. They go into employment, support services, personal care, lifestyle, finances, legal, and then there's other. Then on page 8, here we go. If we have multiple supporters, then the individual will have to let them know, do they work together? Do they work, if supporter 1's not available, is it supporter 2? Or is there another arrangement that the individual wants for their supporters? And then you can also talk about supplemental supporters. Section 3 is completed if the individual has a court-appointed guardian. If they don't, they check that box. If they do, then they talk about whether the agreement affects their authority, and then it would have to go to court. Or if the agreement does not affect their authority, they would provide a copy to the guardian. Then if we go down to page 10, this is if there's any other legal representatives that an individual might have. If they have a power of attorney or an advanced medical directive, then they would list who those individuals are. And it, again, on this form, it kind of talks about it doesn't supplant the authority, and it does not provide authority for these agency positions. If the adult has a trust that's for their benefit, they would also list who their trustee is for their trust, so that they can also get a copy of this agreement. Then we talk about ending the agreement and the effective date. It can be for a limited time, or it can be until such time that the individual chooses to revoke the agreement. And then there's the signatures and consent. So this page is for the individual, and then the next 2 pages are for the supporter. And this goes into the permissions that they have, and they will confirm. And then there's witnesses. So, I mean, it's really designed to be easy to complete. It just depends on how many supporters an individual is choosing to work with. The adult can, we're going to skip the next couple of slides. Those are the requirements in Maryland, which that agreement kind of goes through, but it's there for your reference if you're working on this later. The adult can revoke their agreement at any time, and a supporter can resign by giving notice to the adult or any other supporters or a third party who has a copy of the agreement on file. Third parties can rely on this SDMA in good faith, but third parties can be held liable if they fail to give effect to the adult's decision made in accordance with the valid agreement, or if they fail to provide information that the adult or the supporter would need to make an informed decision or provide informed consent. But again, let's go back to the simplicity of the document. It really is supposed to be user-friendly, that you can create it yourself. Yep, we can move to the next slide. We're going to go in briefly and talk about the power of attorney, advanced medical directive, and trustee. And then I'll talk to you towards the end about how a supportive decision-making agreement works in conjunction with this. So the power to execute a power of attorney, the capacity for this, there is no specific legal guidance. It's, does the client understand what property he or she has? And are they able to communicate what they want to have happen with their financial affairs? We have lots of folks that are not good at managing money, but that doesn't mean that they are incapacitated and unable to do it. And this is where that practice kind of comes into play. For those with school-age children, do they understand about the exchange of money, where it comes from, how to interact in a transaction for a purchase? Do they use a gift card maybe to make a purchase, or a prepaid bank card? Are they getting practice with that to understand the exchange of money and how to track what they're spending? We can go to the next slide. And this kind of talks about just some more details about the power of attorney, and the agency piece is you as the principal, the person that's creating the document and selecting your agent. You are granting them power to act as you, or to stand in your shoes when you execute a power of attorney. And that's why this is a really important document, that you want to make sure the person you pick as your agent is someone that you can trust. Because if you can open a bank account, they can. If you can close it, they can. This is buying and selling a house, signing a lease, signing a contract that might have a financial attachment to it, act on your behalf for court. Those are all the things that a power of attorney encompass. But it is a way to avoid guardianship. It is an alternative. And then if you want to go to the next slide. Capacity for healthcare decisions. This one has a statute that goes along with it to make sure that you're competent to consent to your own medical treatment, which means you're at least 18 years old and you haven't been determined incapable of making an informed decision. And when we talk about informed decisions in the medical sphere, it's, do you understand the nature, extent, or the consequences of a proposed course of treatment? Can you make a rational evaluation of the burdens, risks, or benefits of the treatment? And can you communicate your wishes for the treatment or not? Then we can go to the next slide. And this kind of covers a little bit about your advanced medical directive. Again, it's an agent to make decisions when you are not able to make decisions for yourself. And it talks about life-sustaining procedures, or withdrawing treatment, nutrition, hydration, organ donation, pregnancy. And if you have questions about these documents, I would be happy to answer those. We can go to the next slide. And then if you have a trust for your child, or if you're interested in a trust for your child, it's understanding, this is just give you some ideas of the duties of a trustee. That person is a fiduciary and would be managing assets on behalf of the beneficiary. Could be money, could be property, could be both. And in the special needs world, the beneficiary, if it's a special needs trust, has no access to demand a withdrawal or a payment from the trustee. So that's where you kind of fall in line with, in the supportive decision-making world, it would be, this might be an activity that the adult is interested in and may need funds to help pay for it. And that's where they can work to communicate with the trustee to say, here's what I'd like to do. Here's how much it will cost. Here's why I would like to do it, and be able to express that to the trustee so that they could make a distribution. And then the next slide, this is just a little bit more on the resources and support that goes with alternatives to guardianship and supportive decision making. And then we can go to questions, but I'm going to kind of talk about how these work together. And I'm going to use my older brother as an example. He was born with a cleft palate. He is permanently deaf in his right ear, and he recently was diagnosed with a returning brain tumor. This time he has asked for my assistance with his medical treatment instead of our parents. And while he has made me his agent for his advanced medical directive, we have an informal supportive decision-making agreement. He has capacity, but because of his hearing impairment and the radiation and chemo, we've noticed that there's sometimes some memory or some cognitive issues that have been happening. So I now join him when he goes to the doctor to see his oncologist. And one of the things that I do with him before we meet is we talk about how he's feeling, what questions he might have for the doctor. And I'm really there just to take notes and to make sure that he gets answers to his questions. So sometimes he doesn't always remember to ask them. So I'm there for that prompt, and then I'm also there to make sure that they're answered. And one of the problems with the oncologist office is they're all masking still, just for the safety of patients. So he can't read lips. And then sometimes he can't hear them. So I'm just there to make sure he's getting all of his information so that he can decide how he wants to continue with his treatment. We do talk about it, but ultimately I know it's his decision on what he wants to have happen. But that's really an example of how these can work together when you do a more formalized agreement using that template. So I know I'm running a little bit early on the 45 minutes for the presentation, but I really prefer to kind of go over things and then allow for more questions from our participants.